surmountable trial prejudice. Regarding the third ground, Thales argued that this court erred in finding that the evidence of Mr. Triman and Ms. Gueria can sufficiently substitute the evidence of Messias Meinong and Tetat. Again, no such finding was made by this court. The issue between the state and the defense regarding Mr. Triman and Ms. Gueria is whether they should be called as witnesses in the defense case. In this regard, the parties expressed contrasting views which at this stage of the proceedings could only be decided on the papers. That being the case, the court, relying on Plascon Evans Paints Ltd versus Van Riebeeck Paints Ltd 1984 3 SA 623A, chose to prefer a contention made by the state that a decision whether to call Mr. Triman and or Ms. Gueria rests entirely on Thales. The fourth ground related to the court's finding regarding the probative value of the evidence of Mr. Triman and Ms. Gueria. By implication, it was suggested that this court could and should have pronounced that the evidence of these witnesses could never have any probative value. The view held by the court was that the value to be attached to the evidence sought to be adduced by Thales will only be known once evidence has been presented. It would therefore be speculative at this stage of the proceedings, so the court held, to pronounce on the probative value of the evidence of Mr. Triman and Ms. Gueria. I am not persuaded that another court will find differently. The fifth ground of appeal related to the court's finding that Thales failed to show that Mr. Tetat would have assisted it had he been alive. In my judgment, I contrast what Thales now says in the present application with what it said in 2018 in support of its application for the permanent stay of prosecution. The case now being made by Thales, namely, that Mr. Tetat would have testified that he had been alive, is contrary to the case it made in 2018, namely, that Mr. Tetat is not willing to testify, quote, in any forum, under any circumstances, should a trial take place, close quotations. In argument, Thales again shifted the goalpost. While conceding that Mr. Tetat had expressed his unwillingness to testify, Mr. Roux SC contended that it matters not that he is unwilling to testify. What matters is that he would have been subpoenaed because he is a compellable witness. This issue pertaining to Mr. Tetat's willingness to testify was pertinently dealt with by the state in its answering affidavit when it called on Thales to explain when, between November 2018 and his death on 5 September 2022, did Mr. Tetat decide to change his mind, to which Thales proffered no reply. From the above, it is clear that Thales's contention regarding its inability to lead Mr. Tetat's testimony is opportunistic. I am therefore not persuaded that prospects of overturning this court's finding that Thales failed to show that Mr. Tetat will have assisted it exist. Both Mr. Zuma and Thales conceded that this court was correct in concluding that the relief sought directing the state to stop the prosecution in terms of Section 6B of the Act was incompetent. It is therefore not necessary to belabor this point. At the inception of his argument, Mr. Mbofu SC again reiterated comments made at the hearing of the application, that the application before court is not Zuma's, but that it is Thales's. In his words, they were merely passengers in the motor vehicle driven by Thales. Those comments reinforce a finding made by this court in its judgment that if Thales's case fails, then Mr. Zuma's should also fail. Mr. Mpofu contended that Mr. Zuma's application for leave to appeal should succeed for two reasons. First, on the basis that there are reasonable prospects of success on appeal, and second, because there are compelling reasons to grant the appeal. Mr. Mpofu's main ground of appeal is anchored on the proposition that this court mischaracterized the case it adjudicated upon. The case before court, so he argued, was an application under Section 35(3)(I), not Section 35(3)(D) of the Constitution of the Republic of South Africa 1996, as characterized by the court. He thus contended that there are reasonable prospects of another court finding that what this court decided was not what Thales' case was about. Subsections 35(3)(D) and I provide that, quote, every accused person has a right to a fair trial, which includes the right, D, to have their trial begin and conclude without unreasonable delay, I, to adduce and challenge evidence, close quotations. Mr. Mpofu contended that what the court decided was trial prejudice based on a delay in the prosecution of Mr. Zuma and Thales, that is in terms of Section 35(3)(D), and not trial prejudice based on Mr. Zuma's and Thales' right to adduce and challenge evidence, that is in terms of Section 35(3)(I). There is no merit in that contention. It is clear from the judgment that this court was alive to the fact that the case before it was not about delay-induced prejudice, but trial prejudice associated with Mr. Zuma's and Thales' constitutional right to adduce and challenge evidence. Although an issue was made in the papers on undue delay, both by the state and Thales, the court made it patently clear in its judgment that Thales' case was not decided on delayed prosecution. Whilst acknowledging the presence of a delay, the court pointedly decided not to attribute blame for the delayed prosecution to any party, but instead focused its attention on the question whether, on the facts, Mr. Zuma and Thales succeeded in establishing trial prejudice emanating from the non-availability of Messias Maynor and Tetard. Mr. Mpofu's criticism of the court's reliance on Botma is misplaced. It is worth mentioning that both the state and Thales also relied on Botma in support of their respective cases. I am not persuaded that they were wrong. Their reliance on Botma was well made. Their argument focused squarely on the test for establishing irreparable or insurmountable trial prejudice. It is correct, as Mr. Mpofu contended, that unlike in the present application, the Court of First Instance, which is the High Court in Botma, had been called upon to decide a permanent stay of prosecution brought under Section 342, capital letter A of the Act. But that is neither here nor there. It is not the delay test, as contended, that this court relied upon in determining Thales' and Mr. Zuma's trial prejudice rights. In fact, this court's brief discussion on Botma begins with Constitutional Court's criticism of the High Court's reliance only on the length of the delay, the reasons for the delay, and the trial prejudice caused to Mr. Els by the delay in prosecuting the matter. The criticism of this court's reliance on Sanderson versus Attorney General Eastern Cape, 1997 ZACC 18, 1998 2 SA 38 CC, paragraph 38, was also misplaced. The reliance on Sanderson was directed squarely at two issues. A, the test applicable in barring the prosecution before the trial begins, eloquently described by the court as far-reaching, and B, reliance on hypothecated evidence in a permanent stay application. I am not persuaded that another court will find that this court's reliance on Sanderson was misplaced. Having considered all the grounds of appeal relied upon by both Mr. Zuma and Thales, I am not persuaded that there are prospects of success on appeal, neither am I persuaded that there are compelling reasons to grant leave to appeal. In the circumstances, I make the following order. The application for leave to appeal by both Mr. Zuma and Thales is dismissed. Turning to the application brought by the state, when addressing the court in argument, Mr. Roux for Thales alerted the court to the matter of Matric Lupondo versus the state, SCA case number 123 of 2024, which is presently before the Supreme Court of Appeal. I have since established that an appeal in that matter was argued and that the parties are awaiting judgment. The crucial issue in Lupondo, which finds resonance in the state's application, is the question whether the trial court should permit midstream appeals. It is therefore not only for the benefit of the court, but also in the interest of justice to await the decision of the Supreme Court of Appeal before deciding the present application. For that reason, the matter is going to be adjourned to a date in April for judgment in respect of the state's application. The dates suitable to the court in April are the 20th to the 24th of April. It will be the second week of the session in term 3. Term 2. So the 25th will be a Friday, 24th will be a Friday. I think it's best to adjourn it to the 24th of April.
As the court pleases, my Lord, I confirm the state is available on the 24th of April for judgment on the state's application.
Yes, Mr. Buthelezi.
As the court pleases, my Lord, the 24th of April is fine. If I may, my Lord, with regards to the application for leave to appeal,
Yes.
We request that when your registrar hands out the judgment, my Lord, could we please be furnished with a stamped judgment?
Okay.
We've had difficulty in the past with getting a stamp from your office.
All right.
If you could issue that directive that the judgment be stamped.
All right.
Thank you.
Yes, Ms.
As the court pleases, my Lord, that date is also suitable for the second accused.
Right. The matter is therefore adjourned to 24 April this year, 2026, for judgment in respect of the state's application. Sounds as if you are not pleased. All I've expected is the court pleases, but it seems as if you are not pleased. We are adjourned.